In the past several weeks, we've discussed a number of cases dealing with the Fourth Amendment, the one that protects you against unreasonable searches and seizures. Specifically, where we're trying to define what is a search under the Fourth Amendment. Now, if you think about it, the last three cases I uploaded, Katz, Smith versus Maryland, and Cirallo, all dealt with auditory or visual searches by the police. Now, this week, we're going to define a new type of search, which is a physical search by the police. This Supreme Court case is from the year 2000, Bond versus United States. Mr. Bond is traveling to the East Coast on a bus.
Flintstones, meet the Flintstones, they're the modern family. From the town of Bedrock, they're a page right out of history. When you're with the Flintstones, have a yabba dabba do time, a yabba do time, you'll have a gay old time.
His bus gets pulled over at the immigration checkpoint. Border Patrol agents boards the bus and begins to check everyone's documents. After being satisfied that everyone on the bus is a United States citizen or at least has some legal permission to be in the United States, the Border Patrol agents begins to walk towards the front of the bus to leave it. On the way, he touches one of the bags that's sitting in the overhead compartment where the passengers store their bags. He feels a brick-like object inside the bag, so he asks the passenger below if it's his bag.
After obtaining petitioner's consent to open the bag, the agent discovered a brick of methamphetamine. The brick had been wrapped in duct tape until it was oval-shaped and then wrapped in a pair of pants.
The argument here is that was the initial touch of the bag by the Border Patrol agent a search? And if it is, then he really needed to have a search warrant before touching that bag, or at least a permission ahead of time or consent from Mr. Bond, which he didn't have before he touched the bag. Remember I posted a video on the Supreme Court case Cirallo several weeks ago? Well, in that case, the Supreme Court told us that the police flying over somebody else's backyard is not a search under the Fourth Amendment because the person exposes his backyard to the public, so he loses his expectation of privacy. Well, in this case, the government, of course, relies on that case and tells us that because the person exposed his bag to the public by putting it in the overhead compartment, he has lost his expectation of privacy. The Supreme Court says not so fast. After all, Cirallo dealt with a visual search, versus here we have something more of a tactile search, something closer to Terry versus Ohio, a 1968 case dealing with stop and frisk doctrine, recently made famous by the candidate Bloomberg. We continue to analyze this case by looking at Mr. Bond's expectation of privacy. Of course, all passengers can expect that other passengers on the bus or the driver of the bus might touch their bags. But nobody will expect that another passenger will actually feel up your bag to see what's inside. And for that reason, the Supreme Court says that here, what happened to Mr. Bond exceeded his expectation.
When a bus passenger places a bag in an overhead bin, he expects that other passengers or bus employees may move it for one reason or another. But he does not expect that his bag will be physically manipulated in an exploratory manner. And that's exactly what happened here. We therefore hold that the agent's conduct violated the Fourth Amendment.
And it violated the Fourth Amendment because the police did not have a search warrant or any other exception to the search warrant. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.